Welcome back. Morning tea, Mr. Hall. Ready to answer some questions?
Certainly.
Okay.
Thank you for questions. Would now be a convenient time to strategic issue point that you raised, or that Mr. Hall has some comments on that?
Okay, let's start with
Thank you. So the question there, Mr. Chair, relates back to hearing one, strategic direction, where I believe the evidence in relation to those seeking the recognition at a strategic direction level of conservation outcomes through development. So you can summarise that. The short answer is that Mataka clearly is an example of that. Maybe just anticipating where that question might be going, rightly or wrongly, anticipating where the question might be going. It might be therefore that direction is still necessary. Marks yes, it is, for two reasons. One is it provides the high level support for the precinct provisions that we're seeking. So that sets it out in that higher order strategic direction part of the planning, necessary from a structural point of view, and that ultimately helps assists to deliver the precinct provisions in that the precinct part of the plan. But the second part of that answer is, of course, we're here today on behalf of Mataka Station, and that evidence was presented in relation to a range of other clients, and this Mataka won't be presenting at the subdivision hearing, but other clients will, and noting in particular, for example, the management plan subdivision outcomes, which might be very important to retain in the plan. Again, those are very much driven by that strategic direction setting that supports conservation outcomes through subdivision development. If it's in that higher part of the plan, then it's also supported in the other parts of the plan, precincts and subdivision chapters.
Okay, no, thank you. I anticipate that being the answer, but it's sort of help refocus our mind on that. So, as we said before, these options are still open, and we don't finalise any of them until the hearings have closed. And particularly as we knew there would be other matters arising, the hearings that might want us to revisit what we do. Right. And of course, we'll allow council officers to respond to that evidence. Yeah, if you want to, and you're right to reply. So, my first question, I think, it's structural. I think it sort of relates well to your evidence, but also the council's response as well. And that is, you've sort of set out stuff in the overview that says, yeah, this applies and that doesn't apply. And I just want to ask a general question. I mean, the overview statement, I mean, it almost reads like a rule that's set out in the overview statement. I'm just wondering whether that is the intent, is to literally have the overview statement by default setting out some rules, this applies and this doesn't apply. Or whether that's better stated somewhere else. But I'm not going to make a federal case out of this. You'll both agree that that's appropriate.
Yeah, so the drafting there really trying to make it specific where provisions in the underlying zone or overlay do or don't apply, and that was taken largely from the precinct provisions and the approach adopted there, which I had provided to Mr. Hall. Exactly how it sits, I guess there's a question around that. I don't really have a strong view. I'm kind of okay with sitting in the overview, provided that's then supported by commentary at part 1 of the plan that talks about the relationship with precincts and how that's addressed.
Yes.
And that really is addressed in the overview section of precincts in terms of that relationship, potentially. One recommendation I made was not to duplicate the relationship to overlay rules, but there's also those notes under the rule table. So it's set out there as well. So there's a question about whether we need it in both places or one. I don't really have a strong view on that either. It's just making sure that it's clear, I guess.
I suppose what we're saying is, as long as it's consistent,
yeah,
then we both agree that you probably don't have. You have a view?
Yeah, that's right. Just to confirm what I said, that's exactly it. I followed the form that was provided in relation to the horticulture zone and set it out that way. providing it's consistent, I think, across the precincts is the key thing. And what one possible approach there would be a subheading underneath overview, or another heading that says precinct approach.
Yeah.
That sort of sets up the mechanics of that. So it's not the overview, it's the precinct approach, or words to that effect. That sort of describes how the mechanics of that work is another possibility. I appreciate that there's various precincts being developed simultaneously here, so there needs to be consistency.
That's the difficulty with it, is that everybody's wanting to have their precinct self-contained, but the fact is that there's other precincts as well. So the approach to the plan is perhaps more generic. And maybe there's a more generic way of dealing with it. The precinct approach, or something similar to what you said, might be the most efficient way to do it.
Yeah, I guess the key point is just making sure that you're modifying those underlying zones, provisions and overlays in very specific.
I have no doubt that those statements are relevant, probably do need to be made. It's just really part of the overview, which is traditionally not being even taken as an objective. It might help inform objectives, but it's usually not a statutory part of the chapter. Here is saying this applies and this doesn't apply.
Yeah, the difficulty is you're going to get people looking at the precinct provisions and expecting them to be pretty much fully self-contained. So there's almost a case for having to have some sort of generic statement about precincts, and then having that statement.
That's right. And in my evidence, I set out the generic precinct, but I mean, I'd be happy to. It's a subtle restructuring of that upfront.
So haven't we
present
talk to each other and agree.
And
And first of all, I think I'd say the only thing would be interesting is whether you'd be happy for that to be consistent across all the other precincts. I think you're reporting on my.
The intent, obviously Kenton's got Murikiki, which would adopt this approach.
I won't go that any further. Yeah, I had written a note about objective 4 and the use of the word protect. I understand your evidence about the word protect, but I'm not sure whether it should not have a word there. And I'm wondering whether there is another word that you could put in there, because it seems to be that I understand what you're saying is that the protect mechanisms are already there in the other overlay provisions. I get that. And generally we're not wanting to sort of repeat large sections of that. But it seems to me that whether it's protected, you're referring to those characteristics and amenity values that are integral to matter control, and that you should qualify that with something.
So someone suggested the word acknowledge. I don't know if it came through your evidence.
No, that was yesterday, the landing people acknowledge and respect. What does that mean to a consent? What does that mean to a consent officer? So I'm just wondering, maybe maintain, enhance, is that possibly? I mean, if you don't want to have that sort of really forward-facing directive word protect, which sort of means avoid, if not more. Whether it's maintain, enhance, something else that reflects those characteristics and amenity values that are so important.
I guess the starting point of that objective is what is being directed here. It's new residential units.
Yes.
It's the structures,
Yes.
designs. Yes, it's the built part. So the built part can do certain things, and what it can definitely do is be integrated with.
Yes.
And so the directive of the objective is very much around integration of those things. Yes, they are also directed to protect through other objectives in the plan. Potentially they could, those built forms could also maintain and enhance, but potentially.
Well, that's what I'm thinking, because, going back to Mr. Williams' excellent evidence this morning, particularly about the effort we've put in so far, and that these qualities are there because of the inherent nature of the site and the work that you've done over 20 years. Those are the characteristics and qualities and qualities. Those are the characteristics and qualities I would have thought you would have at least want to maintain. But it's there, and you put the effort in.
Yeah,
and that's what makes you. And again, that's what makes you so special.
Well, I think the other aspect is that the objectives, do have to be read in the whole. So objective 1 it is that the rugged beauty and quality of the environment protected and enhanced, because that's protection enhancement obligation there. Then this next one, as I say, deals with the specific land use characteristics. I think, you know, it's not a normal RMA term, but certainly, yeah, and I also wanted to say maintain and enhance our obligations of the overlays also. So I'm seeking to avoid repetition on this and actually providing more specific directions. And my preference would be integrated with, definitely, but you know, whether we wanted to point to acknowledgement, so they acknowledge the characteristics. I'm just not entirely convincing as an RMA directive, and that's why I'm
thinking about a consent plan, and I've put this to a number of witnesses that myself in the shoes of the consent plan, thinking what's the problem? And here, and what are the consents that they're going to be considering? It's the new dwelling rights, the new dwellings. So giving a consent planner as much sort of direction, clarity in that objective as we can. And so I think a consent plan will be naturally drawn to and they'll be one thing, right? What's driving my assessment here? And then you see these characteristics and qualities. That's why I thought that maybe we could think about something like maintain and enhance.
I think we can think about that and come back on that.
Yeah. And I'm interested in your thoughts, Mr. White, later on.
It's interesting, just as beyond that. I mean, I think the more words you introduce to those objectives, the more meaningless they become. It actually becomes quite hard, like apart from what the chair's saying about the reporting officer, put yourself in the hands of a commissioner looking at something on an application, maintain and enhance and the objectives, and you know, what is it? How can you put a building into some of those environments and still maintain and enhance what's there? There's got to be an element of detraction by the fact that you're putting it there, and that's where I think, you know, the point about integration is probably the key word there.
And that's certainly the drafting approach I've taken. I haven't sought to just replicate it, as you often see, higher order policy direction and drop it in there because they still apply. And, you know, for example, the objective one, the rugged beauty and quality of the environment station is protected. I mean, that very deliberately, specifically explains what you see at Mataka rather than just the generic statement. So, as I say, my preference is, strong preference is integrate with, but we might just have some time to think about what might couple that if necessary.
Yeah, no, I certainly have no issue with integrating with. That's a really important element. It's just something.
Mr. Chairman, could I just make a comment here, please? It's John.
Yes.
I was just going to your reference to protect and Mr. Hall's reference to the coastal environment chapter and other relevant documents. It's within those chapters through the regional plan where those characteristics, qualities and values of the ONL are identified. And so I think to me, it's quite clear that when assessing development within an ONL and the coastal environment, that those things that have been identified within those assessments, which are now part of the regional plan and the proposed district plan, that those are the things that are quite clearly stated there. So I don't feel the need to have another word there. From a landscape perspective, I think integrated is the best word because, as Mr. Hall said, I think the others are covered within those other chapters. If there was to be another word, I would suggest maintain is probably the most appropriate because I think I don't see how the buildings themselves will enhance the you know, those characteristics and qualities, but certainly they should be designed and placed in a manner that should be able to maintain those. So for what it's worth, that's my my commentary on that issue.
Yeah, no, thank you. That is helpful. And I was thinking the word maintain after hearing Mr. Williams' evidence. You know, it would seem to me that maintain may be more appropriate word if we were to put one in, because you've obviously done a lot of work and there's a lot of things there that you would want to maintain. And I don't think there's a hell of a lot of extra work that you're looking to do. What I got the word is that it's already there. I think there might be a little bit of a disconnect is that you do have a number of house sites that are outside the coastal environment plan. And so you wouldn't have those objectives applying automatically. And on that basis, in recognising that there are some house sites outside of those layers, whether it's worth having at least a reference to home, so that they are captured by that. So when they are within the coastal environment, high natural character areas, then yep, those objectives. Those are things like 4 or 5. Then maybe it needs to be
Yeah, I think, and it will become apparent when you're on the site, but there is a clear division. There's very clearly the internal part of the site very much is rural production, doesn't exhibit those coastal outstanding landscape values, etc. And so the policy approach there has been to say, well, the rural production objectives and policies more or less are applicable to those, and in addition to those, we've added some additional policies. So yeah, this policy objectives was very much directed around the O&L and the coastal environment recognition of that side of the precinct. It's very distinct from the internal area.
But the values of the site go beyond obviously the coastal environment. It's the whole property itself. And those qualities extend beyond the coastal environment, obviously. And you would look, obviously, you'd want to maintain those ones.
And I think this is where that objective 1 around the rugged beauty and quality of the environment, the quality of the environment, wholesale is protected and that's a generic statement.
Okay, well, that's something to think about. I won't take it any further, and I'll let my other commissioners ask some questions. So thank you. Thank you, Mr. Goodwin. There might be some more questions there.
Yeah, just the question of height. And it might be addressed by either Mr. Hall or Mr. Goodwin. So it's 5 or 6 metres, basically the prevailing height standards, aren't they? There's provision on 2 lots, which is I think 19 and 23, for the height to go to 9 metres. Just the rationale for that, given that those 2 lots seem to be quite, at least in plan, they seem to be quite prominent lots right on the coastline. Just what is the rationale for allowing a greater height on those 2 particular sites?
Yeah, so the height table is set out in that rule, which I think is the one you're referring to, standard S1, and it sets out the different height limits that apply to the two sites which 9 metres apply are 21 and 22, and those are both rural production zone heights. And so in those instances, the rural production zone would normally provide 12 metres, and we've said in recognition of the characteristics of much of the station, apply the 9 metre to those heights.
So those sites that are not prominent from the coast, does that relate to the fact that they're not necessarily prominent in the coastal environment?
That's correct. Yeah, Mr. Williams had an answer. The bimes too.
No problem.
21 and 22 are not just further off the coast, but they sit behind ridge lines in front between them and the sea.
Yep.
That takes them more out of the landscape. Sorry, the viewscape from the water. So we actually as a family looked at one of them. Should we do that? And we went, no, it's actually hidden behind. So they are, those 2 are a bit different. They're not just production.
Okay.
Place. You're actually almost protected by the foreground, not the background.
Yes.
And maybe just to clarify my answer, they are in the rural production zone, but outside of the overlays. And so probably the easiest way to explain that is on figure 4 of Mr. Goodwin's evidence, which shows the coastal environment line. And as is typical in identifying the coastal environment, that's back to the dominant ridge from the coastline. And these are on the back side of that dominant
Yes.
ridge.
And we could see that tomorrow. Is the 9 meters, sorry, is the 9 meters to give them a view to the coastline, or is it because it's not got a view to the coastline?
It's obviously not common.
So it's
Well,
not like,
sorry,
it's not allowing them to peek over the ridge line so that the upper floors.
They've got one, Mr. Chairman, but they're actually quite a long way back.
Yeah, I see it.
It's more that they're on more set back a bit.
That's the inference though, is that, are you trying to get up 9 meters to peek over the forge?
Well, it's, sorry.
This is definitely not a situation where you've got a big sand dune and everybody's trying to go above it. That's not.
So why 9 meters though? Why is it so different to 5 and 6?
Well, that's just going to explain the backgrounds opposite to that peeking over rationale. It's not that at all. It's that being outside the overlays under normal circumstances, 12 metres would apply. And we looked at that and said, well, is 12 metres appropriate within this precinct? And the short answer was no, but 2 stories is appropriate. And so 9 metres was selected for that reason.
You could argue you're coming at it the wrong way though. You're taking 12 meters as your base and you're coming down. What might be okay? Why don't you take 5 or 6 as your base and move up to 7 or 8? Why leap up to 9, which could arguably be 3 stories?
Well, the rationale is 2 stories and a subfloor. So, normal sort of 9 metre residential dwelling height.
Do your guidelines stipulate roof form?
Do they stipulate 2 stories?
No.
I know they don't. So why not 8 meters?
It's probably all right. Sort of feels like frustrating a little bit with numbers, but as I say,
Well, it's harder to achieve a 3-story building.
I don't know. I'm just happy to see Mr. Hall stumped for a little while.
Oh, no, I'll keep going. The other aspect of some of these height controls, including this one, is recognition of rolling height. And so I think I've talked about before, where a flat 8 metres and top off the edge of the building, where you've got a rolling height limit. So we've thought about 2 stories, and we've thought about a little bit of additional flexibility as the rationale.
Well, we'll probably get a comment during the course of the hearing from the officers as well, rather than waiting for the right to reply, they might have a comment. We've got.
And we'll see it tomorrow as well.
That's fine, thanks. The only other question I had was maybe more for Mr. Williams, just the mechanisms to maintain the situation. We've got all sorts of covenants and bits and pieces from a legal point of view, and I know you know a little bit about that side of things. Then you've got the planning provisions through this process to try and maintain this in perpetuity. So you're quite confident what we're looking at now is going to maintain this, that it's a better approach than we might have had 10 or 15 years ago?
Yes, definitely. We don't have any attacks, so to speak, from either investors or purchasers, but people do want to do their own thing. And the rules, the zone rules as they apply at the moment actually help us a lot in policing this, because we can just say, well, this is not us. We're not doing this. We've agreed to this, and and then how I see, and the minute the draft came out on this scheme review, we had people kicking back saying, hey, if the deal with the council doesn't give us any certainty, then we are going to have trouble if we ever decide to sell, because the people coming in are going to have a look at the environment, and most of the people that are buying here are buying because of those protections. So if that all gets wobbly, then we can't sell as easily. And so in a curious kind of way, the rules, either the zone rules or precinct rules, help a lot.
Okay, thanks. Thanks, Rob.
I had questions relating to the vegetation on the site, and because we've talked about vegetation clearance. So there's established vegetation that was done over many years, stages 1 and 2. I thought that the maps from Mr. Goodwin were really helpful, particularly on figure 6 where it showed the existing houses, and then the green squares for the proposed house locations. So because the subdivision's already done, the only, incoming effects will be the built form, the built development. But also, and there's mechanisms related to that. I can't see a plan here that Mr. Goodwin's done that shows the existing established revegetation and bush that's protected. I can see a number of plans from the original stage 1 and stage 2 subdivisions, which did include a full landscape assessment, which is also attached, which is very helpful. But in terms of what we see the precinct plan, and I'm just thinking what's actually going to go into the precinct itself, and a map potentially to show that vegetation as a layer. And I'm not sure if Mr. Goodwin or Mr. Hall can respond regarding that question, because I thought that the figure 4 in particular was really helpful, where it shows the planning overlays, but we don't have an overlay that I have seen, but I might have missed it here, that shows the vegetation.
Yeah, and so the origin of precinct plan 1 is to reflect rules in the precinct. So in other words, if there's no specific rule in the precinct, my approach is not to show it on the precinct plan. And so in relation to vegetation clearance, certainly on the titles and instruments on the titles, the various layers of protection of vegetation is apparent. And then on the individual resource consents which follow in relation to that, where a site is developed, there'll be further vegetation which will be planted in relation to that, and consent conditions apply to that. So that presents quite a complex, multi-layered sequence of vegetation control, which still exists, but there is no equivalent rule in the precinct, nor do I think there's a need for the precinct to reflect that. Therefore, I haven't reflected that vegetation on the precinct plan, simply because there's no equivalent rule. So the precinct plan, it shows the precinct boundaries, it shows the house sites, and it shows in relation to height limits, but it doesn't show everything. For example, it doesn't show the roading, it doesn't show the archaeological sites. There's various additional layers which have not been included in the precinct plan because they're not rule. And vegetation is one of those.
No, I think that was my question. The sites that we've had do submissions hadn't completed all of their subdivision aspects, so had more of a staged approach with doing additional restoration and additional planting areas. But your site is different in that you've already done the subdivision. So that was the only point.
Can I just pick up on that height one again? Just looking at that height rule, maximum height rule, there's nothing there that would prevent somebody, and I know there's all the RDA assessment criteria and the like, or controlled activity assessment criteria, but there's nothing to prevent somebody on lots 21 and 22 having a shot at 3 stories. I mean, it basically just says that on lots 21 and 22, there may be more than 1 story. Maybe it should read maybe 2 stories.
I wouldn't disagree with that. Because as you point out, we've got that 1-story rule in relation to the other. So
Yes.
the intention is to allow potentially 2 stories on 21 and 22. Then
Yeah.
so.
And the 9 metres still gives you the opportunity for architectural features or the roof line or the like. Okay. Throw that into the pile.
Okay, well, thank you very much. I think that concludes your presentation.
Thank you.
Because we're, in a slightly bespoke process, bespoke zone, what we allow council officers to give a response to the evidence and maybe have a discussion that way. They have the right to ponder things and do it in the written right reply at the end when we have a big summary. But Mr. White and Ms. Absalom, would you like to give us any response to the rebuttal evidence and the answer that we've been to that?
As I said yesterday, the outstanding issues from my perspective are relatively minor in level of detail. Really just 2 points I want to make. First one relates to paragraph 18B of Mr. Hall's evidence, and that's generally supportive of the recommended amendments to the matters of control and discretion, requesting that only refer to ONL compared to natural landscapes more broadly. And this is a question that I think you raised. There are house sites that are outside ONLs, and I think this relates to more than just matters of discretion, also in the policies as to whether it should capture more than ONLs. I guess it's a simple question, and I think this is a matter for Malene.
Yeah, I agree that because there are house sites outside the ONL overlay, if we don't have something other than natural landscapes, if we confine it to ONLs, then we are in effect not talking about those house sites that exist outside. I understand the concern that natural landscape sounds like you've missed a word out, and it should be ONL. Maybe we just have landscapes. The word natural doesn't actually have to be there. We're talking about a managed landscape. It's a managed farm with managed revegetation area. So it could be the characteristics, qualities and values of the coastal environment and landscapes. And landscape, maybe it's not even plural.
I think it was put to us that the ONL line and the coastal environment line are pretty synonymous.
They're very close.
So if it's outside an ONL, the house site is outside the ONL, it's likely to be outside coastal environment overlay, and almost certainly outside a natural character overlay. So that means, so you haven't got another layer of overlay to capture that the precinct doesn't, is that clear? And that you then default to the zone.
That's right.
So in your view, is that a gap that needs to be, is that a gap?
Yes, it is.
And then it needs to be,
Yeah.
and that, is it more, and it's the precinct provisions that should fill that gap?
Well, it's potentially just some tweaks to the provisions, but I guess I'm also mindful is that we do want the focus to be on the characteristics, policies of the coastal environment and the ONLs. We don't really want to lose sight of that reference to ONLs.
Yes.
Potentially.
Yes.
Well, so I think that's.
So I'm not sort of saying that, but I suppose what I'm saying is that if you've got house sites outside of both of them, so you're going to be relying on actually zoning and all the provisions that relate to all dwellings that are in the precinct provisions, right?
Yeah, correct. We could potentially look at if there's sufficient guidance in the rural production zone. I think.
And it might, the answer to that might be it's entirely appropriate to rely on the rural production zone for house sites that are outside of the ONL and coastal environment.
If I could provide a
As I said,
I think the answer is that it almost is, but that's not the approach taken. So there is a more bespoke set of provisions for
and this is where your lower height limit comes in.
lower height limit. So case in point.
And 2 stories.
Exactly. So other than that, they are house sites in the rural production zone where, and significantly separated from the balance of the very large property where there wouldn't normally be bespoke provisions, except though it's a precinct and it's dealt with as a comprehensive whole. So, you know, we have sought to modify those rural production provisions, but haven't sought to introduce a landscape assessment criteria in relation to those, because for the main, under the precinct provisions, if you're sitting on one of those identified house sites, if there is a controlled activity, you know, in those instances with probably very limited need to look back to the assessment criteria, and certainly the basic one, height, materials, colour.
Okay, thanks. Back to you, Ms. Excellent. Thank you for that.
So the last outstanding issue from my perspective is, as Mr. Hall said, I support the restricted discretionary pathway for earthworks associated with the house sites and the common areas, because they would be tripped up by non-compliant rules that wasn't in place, and there's appropriate considerations of those rules to manage effects. But I'm not convinced about the need for a general rule for earthworks and vegetation clearance that's not in place as will help house sites. And that really boils down to, one is the activity status when there's non-compliance, would be discretionary versus non-compliant, and also the control of the permitted pathway for vegetation clearance less than 5 years old versus 10 years old. It's essentially what it boils down to in my view, and we canvassed this issue in hearing 4 as to why a 5-year limit and 3 metre height limit was appropriate for vegetation clearance. In these overlays, there is a more permissive pathway for vegetation clearance in the biodiversity chapter, that's 10 years, but that's for a different purpose, that's ecological purpose. We're talking about an actual character purpose here. So in my view, the more stringent, highly controlled allowance for vegetation clearance is appropriate.
So would that mean that the rule in that part of the plan would apply instead of the precinct rule?
So the precinct rule, in the way I think it should work, the precinct rule would apply to earthworks and vegetation clearance associated with the house sites and the common areas. Otherwise, the coastal environment, yeah, it would apply.
And so you've come up with a rule that would apply outside the house site,
Correct.
inside the precinct.
And just to clarify, and there's two reasons for that. One, I suppose, going back to the fundamental drafting approach here, we can't and haven't assumed that the panel is going to make any particular recommendations in respect to other hearings and 42A reports that it's received. So I have gone back to the plan as notified and identified the need for a more relaxed provision for vegetation earthworks controls. So that's one point. But I think the other point, again, consistent with hearing 4, in my view, that's discretionary activity rather than non-complying, principally driven by the very limited provision for earthworks and vegetation clearance controls. And for example, earthworks is visible from a public place, cut places over 1 metre. You know, there's a very tight set of provisions there, which if a policy construct, in my view, is to allow discretionary activity provision to see through those rather than non-complying, because they at that level of precision and that they warrant a planning approach which would allow discretionary rather than non-complying, which tends to presume against such limits, which I don't think is appropriate in a rural environment, and certainly not at the scale of Matika Station, which comes back to the precinct approach again, where by its nature, very large landscape, it can absorb earthworks and vegetation clearance should that occur as a discretionary activity. You know, this is not, we're not talking permitted activity.
Okay, I think I've repeated both sides of that now. That's
Yeah.
okay. Thanks very much for your presentation and your efforts today. we'll take all the evidence into consideration and seeing our recommendation reports in March next year, which is sooner than. There is still the right of reply to come, so we'll see on that. See what the council officers are thinking. Not consider things further. And I think the right of reply might be delayed a little bit, given the other 4 hearings that were coming up, and also too, one to be consistent with some of the other matters as well. So that'll come in. Well, and will we be seeing any of you tomorrow when we turn up? Yeah, Mr. Wade, look forward. Okay, in the order of things at the moment, we are expected to be there in midday
Correct, yes.
or a little bit earlier.
I've got Don's phone number, is it, to call when you're on their way?
Yeah, right. Have a think about what you really want us to see. And council officers, while we have you here, is there anything you want us specifically to look at?
Sure about the mountain.
Certainly, the 299 metre house sites,
Yes.
I think we need to go and look at.
I thought they were 8.
Good try. That would be the, I mean, you're going to enjoy your visit, I know that. There's nothing specific other than that. I think forecast is good.
Forecast is good for tomorrow, so
Yeah.
fingers crossed. Okay, now thank you for that guidance, and have a think about where those areas that you'd like us to see specifically too.
It would help me if it's possible to know how long do you want to spend there, because they're big, long distances, so.
We're going to the landing after that, aren't we?
Correct.
Yeah, so we need to allow enough time to go to the landing. So we're thinking possibly 2 hours.
Yes,
Is that
no,
possible?
that's done.
I mean, ideally, I'd like to walk down to Marston Cross, but I don't think we'll have enough to do time. It might be on
Again,
another visit.
But that's partly why I'm asking, because what I can do is I'll get the guys to give me the keys, and I can drive you down.
Oh, well, that's a completely different. To make it clear that ideally, I'd like to have enough time to walk it, and I'll possibly do that on my own.
Yes.
Summer or something like that. But if we, yes, okay, because I thought that's an important element.
We didn't get the offer.
It's all about who you know.
Thank you very
Don't
much.
ask about you. Okay, thank you very much.
I am just going to stop the recording now and we need to talk about